This meeting of the Escambia County Board of Adjustment, April 19, 2023, is hereby called to order. With 4 members present, we have a quorum. Will the clerk please swear in members of staff?
Please raise your right hand. Do you solemnly swear and affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Members of the board, copies of staff's resumes have previously been provided and remain on file for reference. The board has previously recognized staff as expert witnesses. Does anyone have any questions regarding their qualifications and abilities to offer expert testimony? Seeing none. The Board of Adjustment meeting package for April 19, 2023 with the Development Services staff's finding of fact has previously been provided for board members. The chair will now entertain a motion to accept the BO meeting package into evidence. Do we have a motion? We have a motion. Do we have a second?
Second.
We have a second. Those in favor signify by raising your right hand. Passes unanimously. Do we have proof of publication?
Yes, sir.
And does the publication meet all the legal requirements?
Yes, sir.
Members of the board, have you reviewed the resume and transcripts of the Board of Adjustment meetings held on March 9, 2023 and March 15, 2023? Upon your review of the resume and transcripts, are there any additions, deletions, or corrections? The chair will now entertain a motion regarding the hearing of those resumes on the Board of Adjustment, previous March 9 and March 15. Do we have a motion?
Mr. Chairman, I'll move them into evidence.
Do we have a second?
I'll second.
Those in favor signify by raising your right hand. Passes unanimously.
Chairman, may I have a vote for waiving of the reading of the legal advertisement, please?
Mr. Chairman, I'll move that we waive the reading of the legal advertisement.
I'll second.
We have a motion, we have a second. Those in favor signify by raising your right hand. Passes unanimously.
The Board of Adjustment hears administrative appeals, variances, and conditional use requests. These hearings are quasi-judicial in nature. Quasi-judicial hearings are like evidentiary hearings in a court of law, however, less formal. All public testimony will be taken under oath. The purpose of the Board of Adjustment and the conduct of this meeting. The Board of Adjustment hears administrative appeals, variances, and conditional uses. All public testimony will be taken under oath, and anyone testifying before the BOA may be subject to cross-examination. All documents and exhibits that the BOA considers are entered into evidence and are made a part of the record. The giving of opinion testimony will be limited to experts, and closing arguments will be limited to the evidence in the record. After hearing the testimony and arguments for and against the proposed action, and before making its decision, the BOA will consider the relevant testimony, the exhibits entered into evidence, and the applicable law. Because decisions of the BOA relating to variances, conditional uses, and extensions of development orders for site plan approval are final unless overturned by a court of competent jurisdiction. The county may issue development orders and permits for properties in accordance with the decision of the BOA. However, if an applicant requests the issuance of such an order or a permit, and such an order or permit is issued, the applicant and not the county shall bear any risk that such a decision may be set aside, that a development order or permit may be revoked, or the development may be otherwise enjoined by the reviewing court. An applicant for relief from the decision of the BOA for said actions or any aggrieved party, as defined by state law, may seek review of such decisions by filing an appropriate pleading in a court of competent jurisdiction within 30 days of the BOA decision. The date of the BOA decision shall be the date the BOA voted at the conclusion of the hearing. Whenever the BOA denies an application, no new application for an identical action on the same parcel shall be accepted for consideration within a period of 180 days of the BOA decision. Any person aggrieved by a decision of the BOA relating to an appeal of an administrative decision may within 15 days thereafter apply to the circuit court for review. Each individual who wishes to address the board regarding a particular issue must complete the blue request to speak form and submit it to the clerk of the board. These forms are located on the table at the back of the commission chambers. You will not be allowed to speak until we receive one of these completed requests to speak forms. We must have these completed forms for the public record.
All written or oral communication outside of this hearing with members of the BOA regarding matters under review today are considered ex parte communications. Ex parte communications are presumed prejudicial under Florida law and must be disclosed as provided in Board of County Commission Resolution 96-13 before a decision by this board or any administrative appeal, variance, or conditional use request. The chair would ask, as each case is heard, that any board member who has been involved in ex parte communication regarding the respective issue to please identify themselves and describe the communication. First case is conditional use 2023-05. Board members, has there been any ex parte communication regarding this case? Seeing none. Does anyone have knowledge or information obtained from a site visit or other sources? Seeing none. Does any board member intend to refrain from voting due to a voting conflict of interest? Seeing none. Would the individuals who are a party to this item please come to the podium, identify yourself at this time, please state your name and address for the record, and wait to be sworn in by the clerk.
Good morning. My name is Nashford Smith. I'm the owner of Good Vibes Jamaican Grill, which is a restaurant.
Please raise your right hand. Do you solemnly swear and affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you.
I think there's a gentleman behind you.
Would you, or if you're going to speak, be sworn in. State your name and address.
I'm Pastor Wes Alvarez, representing My Father's Vineyard, the place of worship and consideration.
This would be a public speaker. You're a
Oh,
public speaker,
Okay.
correct?
Then
This is
you
for the
won't be up just quite yet. And Mr. Smith, were you provided with a copy of the staff's findings of fact?
Yes, sir.
Do you understand all the criteria must be met, and are you in agreement with the findings of the staff?
Yes, sir.
That being the case, with your permission, we'll ask the staff to go ahead and give a synopsis of the case, and then if you want to add anything, you have plenty of time at that time.
No problem. Thank
All
you.
right, thank you very much.
appreciate it. Thank
Okay,
you.
Hi, my name is Christina Smith, urban planner. This is for conditional use 2023-05. This is a location map of the property. This is a 500-foot radius for the zoning. This is a future land use map. This is the CRA map. Here is the aerial map of the property. And you can see the church to the south of it. Here's a public hearing sign on Broad Street. This is looking east onto the subject property from Broad Street. This is the public hearing sign on Highway 29. And this is looking west onto the subject property from Highway 29. This is looking south on Highway 29. And that concludes the maps. So this is for a conditional use request to allow for an on-premise alcohol consumption within 1,000 feet of a place of worship. For criteria A, the proposed use will be conducted and operated in a manner that is compatible with adjacent properties and other properties in the immediate area. As prescribed in the LDC, the board shall review the following regards. According to their website, their hours are Tuesday, Wednesday, Thursday from 10:30 a.m. to 8:30 p.m., Friday and Saturday from 10:30 a.m. to 10 p.m., and closed on Sunday and Monday. The 1,000-foot minimum distance is not achieved. There is one place of worship that are in the vicinity of the proposed use. See the aerial map. The buildings will be visible to each other. Alcohol consumption will be limited to indoors. On-premise alcohol consumption is limited to inside the existing restaurant building as stated by the applicant. No outside consumption of alcohol is proposed. There are conditions or circumstances that would help mitigate any incompatibility. The proposed use will be indoors. For criteria B, there is an ECUA force main located directly in front of the property. Potable water, sanitary sewer, and solid waste disposal are available to the site. And then for criteria C, no modifications to the existing ingress and egress from the site and its structures are proposed by the applicant. Any proposed modifications to the existing on-site circulation must be reviewed by Planning and Zoning for compliance with the Escambia County LDC. For criteria D, there are no nuisances and hazards associated with the proposed use found at this time that would impact the adjoining properties and other properties in the immediate area. Criteria E, solid waste services are provided to the site from ECUA. The on-site solid waste containers are appropriately located and screened from on-site visibility. Criteria F, screening and buffering are not required for the proposed use. If modifications are proposed, they must meet Escambia County screening and buffering requirements as applicable. Criteria G, any proposed changes to the existing signage and lighting will be evaluated through Planning and Zoning for compliance with Escambia County LDC. Criteria H, the existing site characteristics appear to adequately accommodate the proposed use. Any proposed modifications to the existing site characteristics must be evaluated during the site plan review process for compliance with the Escambia County LDC. Criteria I, the parcel is HCLI zoning district, which allows for restaurants, including on-premise consumption of alcohol beverages. Staff findings, staff recommends that the board approve the proposed conditional use as requested.
Board members, any questions of staff?
Mr. Chairman, could we go back to the photographs? This is in an overlay district, is that right?
Yes. It's in the Inslee CRA.
Was there any comment from the CRA on this?
No, sir, this is one of the districts we don't have specific criteria in the LDC regarding.
Okay. Could we go on down now into the photographs again? Okay, next one. Next one. Is the white building the one we're talking about, or which building are we talking about here?
Back up. It's right in the center of the photograph, the one with all the signage on the windows.
This one, past the white building then, right?
Are you referring to the church or the restaurant?
The restaurant is where,
The restaurant is the one, yes, dead center there.
and could you go on down again, the aerial? So the church, the white building is in between, then I take it.
Yes, sir.
About how far, can you estimate the distance between the two? I know it's less than 1,000 feet, of course, but do you have any idea?
Yes, sir. I'll get you a measurement here just real quick. I'm just going building to building. Center of building to center of building is 250 feet, thereabouts.
Okay. And this is a restaurant then? Is that a COP 4 type license we're talking about here?
Yes, sir. A restaurant on-premise consumption permit or license from the state.
Okay. Okay, thanks.
Board members, any other questions of staff? Applicant have any questions of staff? Staff, any questions of the applicant? We do have a speaker.
I would ask, Mr. Chairman, it is the applicant's case. It's the applicant's case to prove. Staff makes a recommendation. We're not the applicant, okay? We're not making their case for them. I would just let him know if he wants to plead his case, now's the time. If you want to go into it and discuss the background on it and your reasonings.
You've already been sworn.
Yes, sir. Okay, so basically, the purpose of me applying for the beer and wine license is one simple fact that the business that I have is now a franchise, and basically, I'm trying to do the franchise throughout the state in that manner. Secondly, there is also a gas station right across from the street from me that also sell beer and wine. A few blocks up the road, there is another like a liquor store, and there's a church right next door to them as well, which also sell to go and everything like that. Maybe about less than a mile down the road, there is like less than 1,000 feet, there is a hotel and also that also sells liquor on the inside, which is right across from me. So I'm just asking to be able to have the opportunity to be able to provide the service like for person who want to buy my franchise, so they can be able to, you know, utilize that service whenever they basically buy it. So my reason for applying for it is to, you know, basically want the same opportunity, just like every other business that's in here, like other restaurants that's doing the same thing like me.
And all your service you plan to have will be inside, is that right?
Yes, sir, that's correct.
And you don't plan to do any kind of drive-in window or anything like that, is
No,
that
sir.
right?
No, sir.
Okay.
Any other questions of the applicant?
Not for the applicant, but I have a question for staff.
All right.
The 1,000-foot measurement we've discussed, and you leave the door and you go out and you do this and that and you turn. What is the actual measurement on this one?
I don't think that's actually been done. As soon as we saw it was within less than 300 feet. I don't know if he's actually applied for that license yet.
Okay. Okay.
Like I said, I'm just measuring center of building to center of building
Right.
is 250 feet, so it's definitely within the 1,000.
Yeah.
Do you have anything else to say, Mr. Smith?
Yeah, I just wanted to say, like, where my property is not visible to the church. It's actually, there is a white building blocking everything. There's also another yellow building blocking it. So from my property, you can't look directly across over there. It's actually in a separate property. So it's not really like in the vicinity where you can see it and it's obvious that it's right there. It's actually blocking. There's a whole bunch of building blocking it. And I'm not gonna sell any liquor on the outside. Everything's gonna be on the inside, because we don't have outdoor chairs or anything like that.
All right. You may have a seat for
Right.
just a moment. We have a speaker, and you may be called again.
All right, thank you.
Mr. Alvarez, please come to the podium and state your name and address and be sworn in.
Pastor Wes Alvarez. My personal address is 6432 Barano Lane, Molino, Florida.
Please raise your right hand. Do you solemnly swear and affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Go ahead.
Here speaking on behalf of the church, we are currently not right now the listed owner of this property. We are in a lease on this property, but we take possession and at the same time combine the two properties to the south of the restaurant. On the 24th of this month, we are purchasing those properties and combining them. They become the entirety of the church, okay? Our concern, our church was established as a teaching and safe haven for people who are coming out of addictions with drugs, alcohol. That's the foundation of our ministry. We use our building every day, every evening. We're not just thinking about times of worship, and we're on the one-way southbound lane of Highway 29, in which our driveways, the exit of the restaurant just north of that, where your cursor is yes, there. That's his exit there. They empty out onto 29. That's the exit of our parking lot. That area is going to become larger parking as we take possession. So our parking there, and then the next driveway is exit out of the church parking lot. We're all going to be exiting onto Highway 29 simultaneously. We're going to be interfacing at the same time with that highway. The areas mentioned in the presentation before, the gas station across the street, none of those locations are consuming on site. People who consume on site then leave and enter public. And that's the concern that we have about interfacing with those who have consumed. Not everybody is a responsible consumer, and I have concerns about, just take Tuesday evenings, for example. We are a satellite location for Covenant Bible College and Seminary. We hold classes on Tuesday evenings. That's a time where we would be sharing exits onto 29. My concern is for those exiting.
Pastor, could you, I'm sorry, I didn't quite catch exactly what was you're in a lease, you have a lease now for the property that you own now, is that correct?
Okay,
You're
the
using
two-
now.
The two driveways that I pointed out, the first one, that one, is, the address is 7995. I am the owner on record for that property.
So in other words, you own where the cursor is now,
Yes, sir.
you own that property?
Yes, sir.
Okay. And you were saying about,
The property to the south is 7895. We close on ownership of that property on the 24th, next week.
when you say we, you mean the
My father's
church?
vineyard, yes, sir. the
I'm
church.
sorry?
My father's vineyard is the church.
So in other words, the church property next week is going to extend into that that rectangle where the two buildings, where the cursor is now?
Those
Is that,
become church.
that will become church
Yes,
property?
sir. So our properties would be right next door. There's no more 100, 200 feet, there's no space. We're right next door.
And is there a fence or anything between the restaurant property and where the cursor was? In other words, their boundary, yes, where it is now, is that just open space?
Yes, sir, it's just wide open. My final concern to present to the board today is we make this exception for alcohol today, and tomorrow we have the exception for a dispensary to be built beside the church. I don't want to open any doors unnecessarily.
I'm curious, staff, was that taken into consideration? Was this point brought up during the process?
That's the first we've heard about the property combination, but until it's done, we have to treat things as they currently are.
Well, the church is the owner of record for the property that is immediately abutted to the property. It's right there to the south. Those two buildings that exist on that property, we own that. We're combining the next southern address to it. So right now, the church is right next door. There's not 100 feet, there's not 25 feet between the two entities. It's the 7895, which is, you have labeled the church, which we lease right now from David Bowen. He made us aware of this hearing, and so that I could come speak, because less than, what are we on, Wednesday today? Next Tuesday, we take ownership of the property and combine the two properties, and we will not be the leaseholder of that property. We'll be the owner of both properties, which will become one property.
I'm sorry, who did you say owns the two buildings, that's in that rectangle we were talking about?
In the rectangle bordered by 3 yellow lines, the church owns that.
The building right there that the cursor's on,
Yes, sir.
and are those, in other words, those are, what you're saying are church-owned buildings?
Yes, sir. That property is owned by my father's vineyard.
And then what about, you said that, if I understand it, then the church is going to formally purchase the land that's labeled as church on the photograph, is that right?
Correct.
So actually, am I right, staff, that the church property itself shares a common border with the restaurant property, is that right? I mean, if I
So
understand the
keep in-
pastor's testimony.
Yes. So the situation, when we go out and measure these, we have to go and, do we find a place that that's an active place of worship? The property immediately next door, while its ownership may be under the church, it was automotive repair, which was a bit different of a use. We don't have any prohibition on anything being served next to an automotive repair. At such time as they combine the properties and then it all, falls under that same heading, then that would change things. But we don't know everyone's future plans. We have to go off what's on the ground.
If I may, church ownership of that property is not future planned. It's already owned by the church. And it's windshield replacement in the small building. They lease that from us. And we park, that photograph, that aerial photograph is actually outdated. If you'll go back to that aerial photograph, the property, you see the big white building on the the property we're discussing, right, that one? Yes, where the cursor is. If you'll move it just north, and you see that land that's right there, that is actually parking. There's no grass there anymore. There is a asphalt milling parking lot that we use. That's why we bought the property, was parking. That is right now church property being used by a place of worship almost every day of the week.
What is in the big white building?
That is leased by a man who stores material. He's a contractor. He stores material in there, and I think he has some old cars in there. But that is going to be ending soon. And that building will revert to church use.
So were you, you said that your landlord notified you of this hearing. Did you not get notified since you own that other property, did you not get
I
notified?
received no notification.
Notices are sent out to the mailing addresses that are listed for each property through the property appraiser's records.
Any other questions of the speaker?
No.
Thank you, sir.
Thank you.
Mr. Chairman, I think we ought to offer Mrs. Smith a chance to rebut any arguments we've heard.
Sure. Mr. Smith?
Yes, so with all due respect, the building that's right next door to the restaurant is actually a different business. It's been there for quite a while. The other white building is basically abandoned, nobody's there. If it's better for me to put a fence around my property, I can do that to make sure everybody is in compliance. So if I need to fence my property all the way around, so there is nobody going off to the church side, I can do that, if that will be okay with everyone. Just to make sure everybody is okay with everything.
We thank you, Mr. Smith.
All right, thank you.
I think, staff, would you like to make a closing statement?
You may have more speakers on this item.
I don't have any more blue sheets. Is there anybody else who wanted to speak? Did you fill out one of these? Come forward and state your name and address and be sworn.
Gary Watson, 1308 North Barcelona Street, Pensacola, Florida.
Please raise your right hand. Do you solemnly swear and affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Go ahead.
Whatever he said, I agree with, but it's interesting that we did not get noticed that this was taking place, and we own the property next door. I just looked up the county records that shows my father's vineyard at my father's vineyard address on Pensacola Boulevard as the owner, and yet we didn't get noticed. If we had not gotten a phone call from David Bowen, who owns the building that we're currently leasing and closing next Tuesday, we wouldn't be here. Y'all would be approving this because no one objected. And so it's interesting. The big building next door, I think someone said it was abandoned or something. It's not abandoned. It's being used currently for storage. The guy's a contractor, and he's got a bunch of antique cars in it. Our plan ultimately is to demolish that building to give us more parking. So today it looks one way, but in reality there's a plan. And so we would be actually butting up against this gentleman's restaurant. We think the world of him. He's been a good neighbor thus far, but we can't do this. We can't do this. Thank you.
Thank you. Any questions of the speaker?
I would just make a comment that I sent out notices no later than April the 4th, is when they should have received them, and it was sent to 7895 Pensacola Boulevard for my father's vineyard.
And we got our tax bill there too. We paid that because we pay taxes on that building because it's a rental property, but didn't get a notice.
Mr. Smith?
Yes, sir. Actually, when I initially applied for the license, this is my first time ever done this. I have no clue what I was supposed to do. So I actually, went to the church and tried to let them know I was doing this. So if they were not noticed, I went there even yesterday, and I tried to say, hey, I don't know what to do. I just want to make sure, what I'm doing, you guys are okay with it. And I spoke to a lady, and she said, oh, she was coming here to help me to make sure everything was okay. But now that I see it's not like that, so I'm just saying I did went there more than one time to let them know. I didn't do this behind anyone's back. I tried to be as upfront as possible, as transparent as possible, because I respect what they're doing, and I want them to respect what I'm doing as well. So I went over there a couple of times just to make sure they were aware of what I was doing. So I'm not going to violate any laws or any rules or any regulation. My intention is to do everything you guys told me to do, keep everything inside, and if I need to put a fence around the property to separate the property so there is nobody going off to their property, I will do that just to make sure I'm in compliance. And that's pretty much it. Thank you.
Thank you. Yes, sir.
Again, Pastor Wes Alvarez, I spoke with Mr. Nash when we came in this morning. The first person that he spoke to representing the church was my maintenance man, my building facility manager. I found out yesterday midday that they had spoken, and I asked him, his name is Francis DeGroat, and I told Francis to reach out to Mr. Nash and let him know that I just found out, and we're not in favor of that. Again, I'd like to reiterate, people who drink inside, come outside, get in cars, and leave. The legal limit for alcohol consumption and driving is .08. That's achieved by drinking 2 beers. Every cop who pulls over a drunk driver asks, have you been drinking? And they're told, I've drank 2 beers. You can be adjudicated guilty of DUI having consumed 2 beers. My concern is not what happens inside the restaurant. It's what happens when those consumers enter traffic on Highway 29, and my congregants have to interface with that. And again, the surrounding areas addressed are purchase here, drink elsewhere, not purchase and consume on site.
Let me ask our counselor. I know we can approve or disapprove, but I'm not sure we have a remedy for the neighbors not getting notice?
It appears that they were given notice. I think that's what your staff was telling you. It was mailed to the correct address. And they are here. So that would constitute constructive notice at a minimum.
Okay.
But I think staff has confirmed that they had the correct address. They were sent a notice. And
So
I'm
a
seeing a yes.
delay in the decision would not be a remedy?
Well, seeing as how they have appeared at the hearing, I don't know that, if they were not given the opportunity because they were not properly notified, then that may be an issue, but they are here, so I don't know what that would accomplish if you were to delay the hearing.
If I may,
And there were signs.
if I may, the owner of the property that where the church is located, do you have on record the dwelling place?
Yes, 1631 Winston Street.
Okay, is that where the notice was sent?
Yes, because that's what the property appraisers would have as the mailing
That's Mr. David Bowen. That's who received the notice.
address.
Well,
For the dwelling place.
But it was also sent to my father's vineyard at 7895 Pensacola Boulevard.
Correct.
Okay, well, regardless of where it was sent, we're here today. That's kind of moot. We're here speaking on behalf of the church and not in favor of that, what is being requested.
Board members, any questions of the speaker? No. Thank you, sir.
Thank you.
Does staff need to make any further comments?
No, sir.
Mr. Smith, do you want to make any comments?
No, sir, I just want to say thank you for having me here.
Okay. The chair will now entertain a motion regarding this item. Your motion, please state whether or not you adopt staff's findings of fact. If for any reason you do not accept staff's findings of fact, please go through all the criteria and address each one specifically as to why you do not concur with staff.
Can we go back to that page? I move we, the staff recommendation.
That you accept staff's
I
findings.
accept staff's findings.
And approve
And approve
the requested
the
conditional use.
requested conditional use.
We have a motion, do we have a second?
Second.
We have a motion, we have a second. Those in favor? Well, any further talk? Any discussion? Those in favor, please raise your right hand. Those opposed, raise your right hand. It's a tie vote. We can get another motion, or the approval fails on a tie vote. Any thoughts? At this point with a tie vote, it is, the conditional use is not approved.
I'll make a couple comments that I don't think that this materially changes the neighborhood in any way. I think that when I look at this, I want to see that the conditional use is going to affect the neighborhood in some substantial way, and I just don't see it. So that's why, I think that approving this conditional use is, while it is outside the 1,000 feet limit, I think that it is a situation where it does not negatively affect the area that it is. So that's my feelings on this.
That doesn't change the motion, and the motion has a tie vote, so
Right, yeah.
it
So the
fails.
motion dies.
Yeah, so the motion does.
Yeah.
So someone else would have to make a motion.
Yeah.
And please bear in mind, as we've learned from recent cases, you have your staff who are expert witnesses who have presented competent substantial evidence recommending approval. The only other evidence, other than the documents and the record, include a fact witness testimony. There is no other expert testimony. So if the motion is to not approve the conditional use, then the board must find that it would be adverse to the public interest, and there must be specific criteria that were not satisfied, and that has to be articulated.
So would a motion for another, asking for what doesn't meet the,
I think that would be part of the discussion. And, too, with a conditional use, correct me if I'm wrong, Drew, the board has the discretion to impose certain requirements of the applicant.
That is
To
absolutely,
mitigate any foreseen nuisance or whatever the justification may be.
absolutely correct.
I'd like to make the motion, but it would just be to basically approve the board's recommendation again. I mean, I'm like him, I see that this isn't going to be an adverse effect by just allowing sale of indoor use, especially if I believe you're not even going to open on Sunday, correct? Yeah, so the busiest time, he's not going to be open. I know the church will be doing other things on other days, but, and I've driven by the place lots of times. Like I said, there's a truck stop across the street, there's the intersection of I-10. I mean, I don't see a real adverse effect of allowing the sale of alcohol.
My concern, Mr. Chairman, is that the full exposition of the property ownership that originally, when I looked at this last night, it appeared to me that central property between the church and the restaurant was neutral ground, I guess you could say. And but now we learn that that apparently is not quite the case. We have a situation where you will have church property essentially backing up to the restaurant, and we've had, although every case is different and every case stands on its own facts and merit, I do note that in the past, we've had similar cases or cases involving somewhat similar circumstances, I guess I should say. And the board has always been very concerned about the situation where you have a church property sharing literally a landline with the applicant in this kind of situation. So that's what concerns me, although there's a part of me, this area, there's no doubt, needs economic development. We should always strive within the bounds of the law to help the small businessman who's trying to increase his business and to employ more people, and I certainly understand that. And that's what makes these cases difficult sometimes, but that's sort of my concern. I really, well, Mr. Chairman, I really am. It was one thing when there was property in between. It's another thing when we're actually going to be sharing a landline between the two.
I think staff articulated that they are governed by the current use of the property, not the owner necessarily.
I'm looking at the property appraiser's page for that 7895 Pensacola Boulevard. The owner is My Father's Vineyard, Inc. Use code is repair service. The property the church is in, the use code is church. Frankly, I don't know how we're supposed to interpret that a automotive repair is a church.
Well, and even assuming it was currently used as a church by the place of worship, does that change the analysis, I think? I mean, you're governed by the criteria in the code. So even assuming it shares a property line, you still have to look at the code and use the criteria to evaluate it.
Do you see any way to, Mr. Godwin, do you see any way to make a motion to satisfy all concerned?
Mr. Chairman, it's going to be difficult. I really do. Assuming for the sake of argument only right now, if we were, if the board was inclined to approve this, I think at the minimum, we would have to have a privacy fence of which the code provides for, and some landscape buffering. Those are, I would think, would be a minimum that we would have to entertain.
Such as a wooden fence?
I would think a wooden fence or whatever. Mr. Homer is much more, could tell us what the code does provide, but I can't support right now this. I can't support, and maybe it's the old lawyer part of me coming out, but if I remember from way back 100 years ago in law school, a lease is still ownership for a term of years. And even if they are in a leasing situation, technically, they have an ownership in the property now. So just because they're the lessee doesn't mean that they're not involved or that they don't have an ownership interest. But laying aside that point, I mean, I think, Mr. Chairman, we would have to have some some things like buffering. In other words, we need, neither person or neither entity, I think, will be very happy by that kind of compromise, but at least I'd be willing, I guess, to talk about this, because right now, if we revoted, my vote would probably stay where it is.
If the maker of the motion amended his motion to include a privacy wooden fence, would that sway your vote?
Yes, sir, I guess so. And also landscaping, I would like to see, in addition to the fence, some landscaping along the border, something that would cut off the sound. But apparently if I understand some of the testimony, those buildings are eventually going to be torn down. Right now, there is a line of sight that is not, is preserved. In other words, the line of sight is not, well, you've got these barriers, so that creates some way that the two parties aren't going to face each other. But once those buildings go, you're going to just have open ground. If I understand the testimony, there'll be a parking lot. Well, I think that you would need the privacy fence and some landscape buffering for sure. I mean, I certainly think that would be something. And also, we have the applicant's testimony that Sunday, he would not be open on Sunday. I think that ought to be included in the
Would the speakers for the church like to comment?
Board, just so you know, there's not a whole lot of room between the south side of the applicant's building and the parking area. You could get a fence in there. I'm not sure you could get landscaping in there.
Not sure you could put a fence there, is that what you said?
You could get a privacy fence in there, but there's not much room for putting in landscaping that could survive.
Fence, but not the landscape, or not the plant?
Yes, sir, it doesn't appear there's room.
Plus, I don't know what it would do to your parking. But you have a comment, go ahead.
The privacy fence in question would have no bearing whatsoever on parking. But again, I would like to reiterate, I'm concerned my concern to the two board members who stated that they see the introduction of drivers who have been drinking to the highway not a concern. We operate out of that building every day of the week. It's not just on Sundays. And I have no problem with how his establishment looks. He keeps it clean. It is nice. It's attractive to the community. My concern is not what happens inside his building. It's what happens when they leave. That is the concern of the church.
Ms. Smith, you have the right.
Yes, sir.
Ms. Smith, you have the right also.
Okay, so I'll make sure, anyone who leave the facility, will make sure they're not intoxicated.
I'm sorry, could you speak up just a
Yes,
bit, Ms. Smith?
yes, I'll make sure anyone who leave the facility is not intoxicated. We'll make sure everyone stay within a certain manner inside. We'll make sure we govern that stuff on the inside. So if for whatever reason somebody complain, then you guys can come by and try to, penalize me for that. I'll make sure that, everything goes according to what you guys stipulate.
Do you have any objection putting up a privacy fence?
No, sir, I can put up a privacy fence. I think that will be fine with me. I could put up one, I could make sure whatever I need to do, I could do that. That's not an issue.
And do you pledge to the board that you will not be open on Sundays?
Yes, sir. I will not be opening Sunday, and I will try to accommodate whatever time they're open. I will try to make sure if they're open and they have a big event, I'll make sure I don't sell stuff on those days as well, just to make sure they're okay with that.
Well, let the minutes reflect that Randy Ponson made the motion.
I'm sorry, Mr. Alderman, said something, please.
Horace.
Let me be sworn in, please. You know, y'all know me, I need to be solemnly. Swear me in, somebody,
Please
please.
raise your right hand. Do you solemnly swear and affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes. I'm sorry I'm late, but I do know about this case. We do need to be conscientious board members, that we do not overly put unnecessary burdens upon this applicant as a business owner. Fencing, also operations, but you do need to respect, he has the right to be in business, and that if he meet the criteria of this board, that should be, with a few minor conditions, that should be reasonable. We do not want to sort of hinder or impact his business operation. And I think that's just mindful. Making certain obligations is good, but going overboard that may impact, because people do eat on Sundays. People do eat on Sundays. I mean, because I've been looking for a good place to eat on Sunday. People just don't cook at home no more. So we don't want him to, with this condition, that he'll never be open on Sunday. If the business start expanding, that may impact his future business as well. Yes, we do want everybody to be in harmony, to live closely by one another, but he is a businessman, and I don't think he's going to jeopardize anything, but we have to respect his rights as a property owner to operate in harmony with everyone.
Thank you, sir.
Okay, let the minutes reflect that Mr. Ponson made the motion, Mr. Padden made the second. I'm asking now if they could consider placing the privacy fence along the boundary there.
That would be with a-
Neither
with a new
party
motion.
seems to object to
That would be
that.
with a new motion.
I'll make a new motion that we accept the board's the staff's recommendation with the addition of the appropriate privacy screening.
I'll second that.
Okay. Any comments?
Mr. Chairman, I know we've faced this matter before, and it's always hard, and Ms. Jones is right about one thing. We certainly want to try to help the small businessman as best we can within the bounds of the law. With that, Mr. Chairman, I would move we go ahead and vote.
Okay, we have a motion to accept staff's findings of,
Recommendation.
I'll second.
and we have a second. Any further discussion?
I got another question. I'm sorry I'm late. Because the cost of construction is extremely high, gentlemen. It's extremely high. This fencing, we do have fence regulations that we have to go by. Is there a time limit? Because the cost of construction is, and I know what this business is, I pass by it daily. We want to make sure, cost of construction is high. Give this gentleman some time. If that's a condition on his fence, we issue fence permits all the time, and it's high, and trying to get people to do those things, especially the height and accommodations, we do have code regulations about that. But we don't want, just someone to call code enforcement said that he conditions the fence and he ain't up there yet. So we do want to be reasonable, per se, with him so that he can get, because believe me, it's high and it's very timely, and we have fence control all the time, and they are so far behind. So we really want to be conscientious of that. So without making it very difficult, and someone calling and saying, well, they say they want a fence, they don't got it up yet. That's because it's really not required. But if that's a condition of this board, you do have those obligations to do that, to make those conditions.
Thank you. Thank you.
Mr. Chairman, I think that
Let one more speaker and then that's it.
I would like to say the testimony of the esteemed speaker notwithstanding, privacy fence is pointless. Do not have him put up a privacy fence. That we have no problem with sound or sight. That's not the issue, okay? Don't put undue expense, unnecessary work on a small business owner. Don't do that. That's not gonna achieve anything. It's not gonna accomplish anything except for taking operational cash out of his hands.
Okay, thank you.
Mr. Chairman, based on that, then I would wonder if the motion might be amended to delete the fence requirement.
I never did require a fence, I just appropriated screening.
To delete screening, then.
I'm amenable to that. Do I have to resubmit that? Do I have to resubmit the motion? He wanted me to.
amend the
he wants-
motion.
Okay, amend the motion that we delete the appropriate screening necessary.
Second.
All in favor, I guess, Mr. Chairman?
Passes unanimously.
Sir, you don't have to worry about a fence or screening of any type, apparently.
Thank you very much. Appreciate it.
Okay.
Thank you. Thanks, Alvin. Thank you. Appreciate it.
Mr. Chairman, I think we need to vote to settle up then on approving the application or accepting the staff's recommendation.
Well, I think we did.
Thought we just-
That was what the motion, yeah.
We just
The
did
motion.
that.
Oh, well. So much. Well, that's why I'm old.
Think somebody wants to speak.
That, you're stealing my lines.
One final question for the board. Are the findings of this board final? Is there a next step?
There is.
30 days. Do you want to explain?
An interested party may appeal within 30 days with the circuit court.
Roger that. Thank y'all.
Gary Watson, real simple question. I don't understand why we're here. If you have a rule that requires an applicant to do this sort of thing and then have to notify places of worship within 1,000 feet, and then you just ignore the rule, I simply don't understand. Why is there even a rule about the 1,000 feet? I don't understand. Can anyone explain that?
We have notice requirements. Those notice requirements were met. We use the addresses that are given through the property appraiser's data. We post a sign and we run an ad in a paper of general circulation. We do not hand deliver notices. We simply send the postcards to those addresses.
I'm not talking about the notices prospect. I'm saying, why would you have a rule about places of worship and then ignore that?
Oh, okay. So every zoning district has allowed uses that are just straight up allowed uses.
Right.
They also have what are conditional uses. Conditional uses require approval through this board. The way I try to explain it to folks is that conditional uses sort of fall into a gray area. They may be more intense than other uses in a particular district. So they come to this board to make that decision of yes or no. The code says, yes, there's a prohibition on on-premise alcohol consumption within 1,000 feet of a church, a school, or daycare. It does give the provision, someone can apply for conditional use through this board if they're within 1,000 feet of a church or daycare.
Okay.
So they're allowed to come to this board and petition for approval of that land use.
But why have the rule if you're gonna ignore the fact that you've got a church or a daycare
It's
within
not a prohibition,
within
sir.
10 feet? Excuse me?
It's not a prohibition.
What is it then?
It's a conditional use that requires this Board of Adjustment to consider the code requirements to determine whether it's an appropriate use in that location.
But again, why even notify the church within 1,000 feet if you're gonna overrule their objection?
Again, it's not a prohibition, and the board has to base their decision on the criteria that's provided in the code.
So if I were a daycare center, we wouldn't be having this discussion?
No, the analysis would be the same essentially.
If it was a public school, would we have this discussion?
There's not an option for conditional use if it's a public school.
Right, right.
Yes, sir.
Again, it makes no sense at all. Thank you.
Okay, that's that. The next case to be heard is variance 2023-01. Would the people who are a party to this event come to the podium and be sworn in?
Can we please wait until Mr. Ponson's back so we have a quorum present? We're very short on members today. We have to be careful.
Board members, has there been any ex parte communication regarding this case? Seeing none, does anyone have knowledge or information obtained from a site visit or other sources? Seeing none, would the individuals who are party to this please come to the podium, identify themselves, and be sworn in by the clerk? I believe you're an attorney, sir?
I just look like one and play one on
Well,
TV.
I'm keeping you from being sworn.
My name is
You
Eric
you will
Dillard
not
at
have to
70.
be sworn.
No,
He does.
Go ahead, state your address.
Ah, okay. I usually get accused of being a doctor.
And
Eric
you
Dillard.
agree with staff's findings of fact.
Chairman, we're going to have him state his name and address and be sworn in. He is not an attorney.
Oh, he isn't?
No.
Okay. It's the bow tie.
I get that a lot. Thank you for the compliment. I am Eric Dillard at 7544 Lily Lane at Pensacola, the address that actually is the case.
Please raise
I'm
your,
the owner.
please raise your right hand. Do you solemnly swear and affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Would you like staff to run through the synopsis of the findings, and then you can address any of it you would like?
Since this is the first time I've done that, thank you for the lead-in, because I'm not sure what to do, so thank you for that. I would like
All
that.
right, watch Drew.
Thank you.
Okay, thank you, sir. You may sit while he goes on the presentation.
I'm sorry, hard of hearing.
You may sit while he
Thank
does
you.
his presentation. Thank you.
Of course.
My name is Christina Smith again, urban planner. This is for case variance 2023-01. Here is the location map of the property. Here is a 500-foot radius for the zoning. This is a future land use map. And here's the aerial map of the property. Here is a public hearing sign posted on the property. Here's looking towards the front of the structure. Here's looking to the west side of the property. Here's looking east of the property line. And that concludes the photography. So the applicant is seeking a variance to reduce the setback from 5 to 0 feet for a pool enclosure. Criteria 1, hold on. Am I reading it? The findings of fact, the lot does have a unique shape with a 10-foot power easement to the east of the property. The property has a decreased slope. These features create a particularly difficult for placing a pool enclosure. Criteria 2, The special conditions and circumstances do not result from the actions of the applicant. They exist due to the layout and topography of the parcel. Criteria 3, granting of the variance would not confer the applicant any special privilege that is denied to other lands. The variance request process is open to all citizens of Escambia County. Criteria 4, the lack of a pool enclosure setback variance would deprive the owner of a right commonly enjoyed by other properties in the area. It would not create an undue hardship. Criteria 5, given the unique features of the property, the requested variance would be necessary to use the land in the same manner as other parcels. Criteria 6, the granting of the variance would be consistent with the general intent and purpose of the Land Development Code, and that such variance would not be injurious to the area or otherwise detrimental to the public welfare. Staff recommendations. Staff finds that the request meets the criteria and recommends approval.
Thank you very much. Board members, any questions of staff? Applicant, would you like to make any comments?
The first comment is thank you for taking the time to listen to me. One other comment that I would make is the place that's adjacent to this property, just so you're aware, the 5-foot variance that I'm asking for, which is only in the rear of the property, not the front of the property. You will also note that there actually is a signed notary from the other homeowner this is adjacent to, where they have no issues with that variance, which that is shown here in my document, and of course you probably have that as well. So I just wanted to say thank you for the initial finding. I do believe I meet all the criteria, and I'm here in case you have any other questions.
Board members, any questions?
So is the setback, is the rear setback that is in question?
Not the rear, if I may. That fence already in existence is 6 to 7 feet inside my property line because there is a ditch that runs behind it, and I didn't want to look at a ditch inside my backyard. So when I initially fenced the property, that is in 6 to 7 feet as the survey shows.
So
We're only in considering is the right side of the property, which is adjacent to the other homeowner, and she's already written and sent to you all the notarized letter, or I sent it to you. There is no other homeowners, if I may, adjacent that this would even be applicable to. That's adjacent to the
pool is on
property.
the other side of the house.
I'm sorry?
That's an older aerial.
That pool is now gone. And there is a power easement over that pool. So that pool is gone. That's the small round one. That photo is old.
So the only neighbor that you're touching then is the house right next to the,
Yes, sir.
okay.
Yeah, this side, I'm only asking for the variance on the right side, and you already have a notarized letter stating from Val that she is in complete agreement with my screen enclosure. I tried to make it easy for you.
Good. Board members, any questions? No question. Chair will now entertain a motion regarding this item. In your motion, please state whether or not you adopt staff's findings of fact. If for any reason you do not accept staff's findings of fact, please go through the criteria and address each one specifically. Do we have a motion?
Mr. Chairman, I'll move that we approve the staff's recommendation.
Motion by Michael. Do we have a second?
I'll second.
Second by Ross. All those in favor signify by raising your right hand. Passes unanimously.
Ladies and gentlemen, I would like to make one closing comment. I have a special needs child, and the ability now to move around the other side of that pool is incredibly important to his health. That was not taken into consideration at all in this process, but I just want to tell you with significant gratitude how important that is to me and to my son's safety. So thank you for your motion.
Thank you, sir.
You're welcome.
The next case is conditional use 202306. Board members, has there been any ex parte communication? Seeing none, does anyone have knowledge or information obtained from a site visit or other sources? Seeing none.
Mr. Chairman, I will have to say, I live in River Gardens, so I go by on 9 Mile Road almost every day. So I'm aware, I'm not made any kind of site visit, but from the highway, I'm aware of the area that we're talking about.
Yeah, I don't see that as any conflict, Counselor.
No.
There is no conflict, sir. Would the individuals who are party to this item please come to the podium, identify yourself, be sworn in by the clerk?
My name is Rich Scholl. I'm the president of the House Corporation in question. My address is 1053 Fleming Drive, Pensacola, Florida.
Please raise your right hand. Do you solemnly swear and affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
And we'll get you associated.
I'm Bill Mitchum. I'm an attorney with Beggs and Lane. My address is 501 Commandencia Street, Pensacola, Florida, 32507.
That's good. Thank you, sir.
Yes, sir.
You were given a copy of the findings, staff's findings.
Yes, I was.
Would you like staff to summarize, and then you can address it as needed?
No need.
Okay,
Yep. Yes, sir. We would like them to summarize it. Yes, sir.
okay.
Okay. Go ahead, pull up that. Andrew Holmer, Escambia County Development Services. This is conditional use case 2023-06. Here we have on the screen the location map, zoning map for the site, showing the zoning on site as commercial. Future land use on the site is mixed use urban. Here we have an aerial map. This is the public hearing sign placed out at 9 Mile. This is looking west into the subject property from the corner of 9 Mile and Denton. This is looking straight across Denton to the front of the property. That's the public hearing sign posted on Brewer Street. And that's looking southeast onto that subject property from Brewster. Okay. All right, let me pull up the findings. All right, so the request is for a fraternity house. In commercial zoning, it allows for group living, but it excludes, under the straight-up allowed uses, dormitories, fraternity, and sorority houses. It becomes a conditional use at that point. In commercial, it allows for, as a conditional use, group living not among the permitted uses of the district. So as to the criterion, the first one, which is general compatibility. This site will host social events, but the primary use will be residential. This commercially zoned parcel is bordered to the east by 9 Mile Road right-of-way and to the south by another commercially zoned parcel under ownership of the fraternity. The parcel to the south received conditional use approval for the same use in 2007. To the west are heavily wooded residential parcels. The general use of the proposal can be compatible with the surrounding uses. Criterion B, facilities and services. ECUA sewer is not currently available to the site, but the current facilities should be sufficient for the proposed use. Any future changes to the site will need to be reviewed for services at that time. Criterion C, on-site circulation. Ingress and egress are provided through a connection to Denton Road. The current parking appears to be sufficient for the primary residential use as proposed. Any expansion of the use will require county review, as the former use, which was place of worship, allowed for grass parking, which would not be an option with other uses. Criterion D, nuisances and hazards. The primary proposed use for the location is residential and should not produce hazardous nuisances or impacts to nearby properties. Criterion E, solid waste. Solid waste service is available to the site through ECUA. F, screening and buffering. Screening and buffering are not required between residential uses, but is encouraged should the applicants wish to enhance the on-site vegetation. Criterion G, signs and lighting. Any signage for the use will need to be reviewed and permitted through the county. Exterior lighting will need to be directed inward. Criterion H, site characteristics. The size and shape of the parcel is adequate to accommodate the proposed use. Criterion I, this is use requirements. The Land Development Code does not provide use-specific requirements for a fraternity house. And findings, staff recommends that the board approve the proposed conditional use as requested.
Can we go back to the map? So the property here to the, I guess that's the west, that's also owned by the same people?
No, sir, the triangle immediately south,
Yeah. That's,
that one, where the cursor, yes.
yeah.
That's the one that received conditional use approval in 2007.
I see that this is not connected to the sanitary sewer.
That's correct. There's not sewer along that side of 9 Mile. Septic would have to be the method of disposal until such time as sewer gets brought to that area.
Oh. Well, I thought that the ECUA and the county's policies were that they would always try to connect with the sewer system.
Yes, connect when available.
So it's not available, is what you're saying?
Correct.
I had a question for the applicant.
Might be rich, but I'll see what I can do to answer it.
This is a wooded neighborhood kind of environment.
Mm-hmm.
Have you had any comments from any of the surrounding neighbors about this proposed project?
We have not, and I'd actually like to point out that you'll see the conditional use, the triangle below. That was the fraternity house for 7 or 8 years, and they had some termite problems. They had to ultimately demolish it. And Rich maybe will speak better to this, but my understanding from discussing with him is that they never received any complaints from any of the adjacent landowners. Really, the only adjacent landowner was the church, the one that's immediately adjacent, which were purchasing that property. But even if you count take into account the folks who are across the streets, there were never any objections or complaints lodged as far as we're aware.
They'd be here if they were.
I would think so too. I would think so too. And again, they could rebuild the on the triangle parcel that is south of there. But right now, there's no plan to do that, and there's no plan to modify the structure that's on the subject property, which is currently served with the, on the septic tank, as he indicated.
Board, any other questions of the staff?
Do we have any blue pages? Any speakers?
Oh, are there any speakers? No, gotcha. Okay, any questions of the applicant? Okay. Chair will now entertain a motion regarding this item. In your motion, please state whether or not you adopt staff's findings of fact. If for any reason you do not accept staff's findings of fact, go through the criteria and address each one. Do we have a motion?
I move that we accept the staff recommendation.
We have a motion by Randy. Do we have a second?
I'll second.
We have a second by Ross. Any discussion? Those in favor signify by raising your right hand. Passes unanimously. Thank you, sir.
Thank you for your time.
We have a discussion item. Are you the leader of that?
Well, I just wanted you all to be aware of a recent order that issued in a very old case, actually, a 2018 appeal on behalf of the Seafarer Owners Association regarding the beach access number 4 on Perdido Key. Your decision was upheld. So the order is in the backup if you'd like to review it.
There's no sign that this is going to go any further, is there? Beyond this?
I don't believe so.
All right. Thank you. And thank you for the job. We appreciate the hard work.
Thank you very much.
Any further discussions? If not,
Mr. Chairman, what do we have on tap for next?
Next month, it's going to be May 17th, and I have a conditional use case, and I'm going to have one property that's going to have a conditional use and a variance on it.
May 17th,
8:30 a.m.
without objection, we stand adjourned.